My name is Leena Heinämäki and I work as a senior researcher in the Northern Institute for Environmental and Minorities Law, Arctic Center, University of Lapland. And today I'm very happy to have my colleague here, Stefan Kirchner, who also works as a senior researcher in the same Northern Institute, Arctic Center with me. Stefan also holds a docentship for fundamental and human rights from the University of Lapland. And Stefan has taught in the international law, especially international litigation, human rights, law of the sea and environmental law, also rights of indigenous peoples at the universities in Finland, Germany, France, Italy, Lithuania and Ukraine. Stefan also was formerly an assistant professor for international law, assistant and later associate professor for international law and law of the sea in Kaunas, Lithuania, associate professor for fundamental and human rights with special focus on indigenous rights in Rovaniemi, University of Lapland. Stefan has been admitted to a bar in Germany, handling mainly cross-border human rights cases, proceedings before the European Court of Human Rights, Federal Constitutional Court also. And Stefan was also formerly government lawyer, actually, specializing on the implementation of international treaties in domestic law. And from 2012 to 2015, Stefan was acting as a co-chair Rights of Indigenous Peoples Interest Group, American Society of International Law. And he has published very extensively, mainly on international law, human rights and the rights of indigenous peoples. Stefan has also been now studying quite extensively both inter-American human rights system and also Latin American countries. So if we talk a little bit about the inter-American system, human rights system first. Inter-American human rights system, meaning Inter-American Human Rights Court and the Commission, the system is regarded as very progressive in many ways. So for indigenous peoples, the right to property related to traditional lands is of a particular interest. So what has been particularly progressive in the Commission and Court actually in terms of right to property?
Yes. In Latin America, we have, of course, a relatively large number of indigenous peoples, and it's an issue which is relevant for a large number of countries there as well. What's special about the Inter-American Court is Article 29 of the American Convention on Human Rights. The Inter-American Court is different from the European Court of Human Rights or the African Court, for example, in that it deals not just with one instrument, the American Convention, but it actually has the obligation to take into account other international treaties which have been ratified by the states in question. So when deciding a case, the Inter-American Court also has to take into account, for example, ILO Convention 169, which has been ratified by a lot of American countries. Yes, here are even customary international law. That means that in developing its case law, it not only is based on one source, on the American Convention, but rather it interprets the American Convention in light of new developments. And that's what it has done with regard to Article 21 of the American Convention, the right to property. When you look at the text of the norm, it's a pretty much straightforward norm protecting the right to property. What the Inter-American Court has done is to go far beyond that. The Inter-American Court in the last 10, 12 years has had a number of cases in which it developed the right to property far beyond what we would normally associate with the term, for example, from domestic law. According to the court, it's no longer necessary for an indigenous community to have a written legal title in order to have property within the meaning of the American Convention, within the meaning of Article 21. It's enough to have traditional occupation of a land, and in some cases the court even found that it's not necessary for a community to even be currently occupying the land in order to have property rights. So even communities which recently lost their land involuntarily, for example, due to violence committed against them, they have still property rights. And this can go in so far that the state has an obligation to give them a written legal title to their land. So this is something very specific. And in its development, in the case law, the court didn't just look at Article 21 of the American Convention, but looked at Article 13 of ILO 169, for example, which relates to the particular relationship indigenous peoples often have to their homeland. Especially when you have a traditional form of livelihood, you're very much dependent on the land you live in. And this is something which has been recognized in Article 13 of ILO Convention 169, and it has been recognized by the Inter-American Court, which said that because of this connection between people, the land, and the culture, the traditional way of life, you cannot just apply the standard methodology of determining what's property within the legal sense of, let's say, domestic law. So these traditional forms of usage of a land, which can also mean usage of land which is not permanent, not year-round, for example. That's something that's also protected, even if it does not fit into property categories that you normally find in domestic law. And so far, it's a huge step forward from the domestic law, and also with regard to the rights of communities which often don't have any written legal title to their land.
Yeah, it's very interesting. So maybe could you give an example of a case where the Inter-American Court dealt with indigenous people's interests regarding their traditional lands? There's a extensive cases, but maybe you give an example.
Of course, there have been many cases, and land rights are an enormously important issue for indigenous peoples. In particular, when taken into account problems like infrastructure measures which are taken by Latin American countries, think for example of hydro energy projects in Brazil or road construction and so on. These are issues which usually affect indigenous peoples very significantly because they use up a lot of land. Just last November there was the case Carlinho Noconho, in which the court actually went beyond land rights on property rights in the traditional sense of the term and gave them also a procedural dimension. It's no longer just okay or sufficient for a state to protect property rights, but rather before taking measures which can harm indigenous peoples, the state has to make sure that it knows if property rights would actually be affected. In that case, it meant that the state has an obligation to actually find out first if indigenous lands are affected by a potential project. So it's no longer just enough for the state to wait for indigenous groups to say that we are affected by your project. Rather, the state has the obligation to protect indigenous people so much that you have to find out in advance, are indigenous territories affected here? And that requires the state to identify these territories. That's an obligation you also find, for example, in Article 14 of ILO Convention 169. In the second step, the Inter-American Court then developed a system which basically describes the current state of customary international law when it comes to free, prior and informed consent of indigenous peoples based on the prior identification of these indigenous lands. Essentially requiring states to establish a mechanism to make sure that the indigenous communities which are affected by a measure are actually consulted, and not just consulted in the sense that they are given a chance to be heard, but rather consulted in an effective way, to give them a possibility to effectively protect their rights and interests.
Yes. Then if we move from the Inter-American very extensive system maybe to more national level, to Latin American countries that you have been also studying now extensively, and particularly if you talk about those countries that have ratified the ILO Convention 169. So maybe you could give a couple of examples how the convention is actually implemented. There's of course variety of ways, but maybe a couple of examples you find interesting at the moment.
I think one thing that one has to keep in mind at the outset is that the situation of indigenous peoples in many parts of Latin America is still very bad. There's widespread discrimination, there's systematic poverty, there's systematic violence in many parts of Latin America, and there's a huge pressure to assimilate. This has serious consequences. In several Latin American countries, there's still big stigma, huge stigma being associated with being indigenous. There might not be the same level of self-organization of indigenous communities. Language barriers also play a role here, of course, but very often the pressure to assimilate is enormous. Against this background, it can be politically difficult for a lot of Latin American countries to actually justify to the voters why they should take measures specifically protecting indigenous peoples. Especially if you think of local communities who might not be indigenous but might be in a very similar social situation. Nevertheless, a couple of countries actually have made huge efforts in the last couple of years, especially in the last 25 years or so, since the late 80s. One reason for that certainly is the fact that Latin America overall is becoming more democratic, that there is tangible change in many countries. One example where there's been a massive change, at least on paper, is Bolivia. Until the 1990s, there was also significant pressure to assimilate, but Bolivia has probably the biggest indigenous population in relative terms in Latin America. And since the 1990s, it's considered a plurinational state. So on paper, the government, the state, embraces indigenous peoples. They are a big part of the overall population. And I think that there should be very clear rules and so on. And unfortunately, that's not always the case. There's often a gap between the law on the paper and the law, the way the law is actually implemented. Bolivia is probably a very dramatic example for this, because there have been cases in which consultation projects simply didn't happen, or the government claimed that they had consulted communities which they never did, or that communities which had been consulted had not been given full or correct information. This is certainly one end of the spectrum where there's a big discrepancy between what would be expected from the written law and how the reality actually looks like. In some other countries, there are concerns which are more important from a domestic perspective than indigenous rights. For example, when you think about energy in Brazil. Brazil is very much dependent on hydro energy, and in case like the Belo Monte Dam project, this is something which is seen as much more important than any other particular interest of local communities, be they indigenous or not. Here we have an enforcement problem, because the state has made this conscious decision that development is more important than indigenous rights. But then there are also examples when the state tries to achieve equality and to deal with several problems at the same time. Colombia, for example, has extended the right to be consulted, to require an informed consent, not just to indigenous communities, but also to other local communities, so-called ethnic communities. The rationale behind this is fairly logical, because there's been a lot of discrimination also against, for example, Afro-Colombians. From a strictly legal perspective, there's a risk that things get mixed up between indigenous rights, minority protection, general human rights, and so on. Here we have a case where certainly the intention behind this has been good, because there has been so much discrimination in the past. The tool might not necessarily be the right one, because it would weaken also the concept of free, prior, and informed consent from an indigenous perspective. One key certainly is that consultation is something which is effective and which really gives indigenous peoples a voice. And this does not end with the consultation itself. A couple of Latin American countries have so-called amparo proceedings, which is a complaint mechanism where you can complain to a court about violations, for example, of your constitutional rights. Colombia has said. Chile is another example which has this. In Chile, the right to live in a non-polluted and healthy environment is protected in the constitution, and you can claim this right in the courts. What has happened there is that whenever indigenous communities felt that the consultation was not fully adequate, it was not appropriate enough, they had the opportunity to actually claim their rights. And the courts, in the case the appeal courts and the Supreme Court in Chile, they take into account not just the right to live in an unpolluted environment, but also, for example, UNDRIP or ILO 169 when making their determination. And here we have a legal tool, the possibility to actually go to court if you want to challenge the decision by the authorities based on the notion that the consultation did not comply with international standards. And that's something very important, I believe, because it gives the communities the ability to actually interact with the government in a third forum, in the courts. It requires, of course, rule of law, and it requires that the courts are actually respected. But once these two requirements are in place, then you really have a valid tool here. And the indigenous communities are actually empowered to make sure that consultation procedures are being maintained.
So, concerning ILO convention implementation, still more specifically, for example, in Bolivia, when you mentioned that it looks good in a paper, so what is it more specifically like? How is this convention being turned into national procedures, and how like, if you give some elements, like what do they try to establish, even though it doesn't reflect the reality, then what are the main things?
Overall, in many Latin American countries, and it's the same probably elsewhere as well, there's an attempt to put, for example, the consultation procedure into the administrative process already, so prior to making a decision about a permit. The problem is, of course, that in many national legal systems, these administrative procedures are not really accessible to outsiders, because in the very beginning, it's a legal relationship between the person who applies, let's say, for a mining permit, company which applies for a mining permit, and the state. Indigenous communities, they're outsiders in this sense. So from a legal perspective, it can be difficult for the nation state to accept that you have to take this outsider into the process already at this early stage. I think that's also a bit of a problem of legal culture in a sense. If you actually have the possibility to challenge a decision by the authorities, even if it only concerns you indirectly. Also, rule of law is an enormously important issue. The implementation of ILO 169 in Latin America is more problematic in countries where you have very limited rule of law, where the courts don't really have the power to enforce the law against the government, for example. The stronger the government in relative terms, in a constitutional sense, the more difficult it becomes to hold it accountable. This lack of accountability is something that we see in places like Bolivia. So you might have laws which sound nice on paper, but if you cannot hold the government accountable for not implementing the law in practice, it becomes very difficult to effect change. Chile, which I just mentioned, is the other example where you have near complete accountability because of the amparo proceedings, because of the possibility to go to court. So the problem is not so much the convention itself or national law, but rather the question, how accountable is the government? How much rule of law do you actually have?
Okay, thank you, Stefan, for these amazing insights. It's not very easy to get the picture of Latin America, but you have been doing an extensive study, and it's important to try to learn some elements of how land rights and indigenous people's rights are being solved in other parts of the world. So thank you very much.
My pleasure.